So we have a lot of leftovers, and including salad. I don't know what you're thinking.
Yeah, I just wanted to have that soup because,
You want to have a soup?
yeah. Why isn't my audio working?
Leftovers. I don't want that soup.
Okay.
Which soup do you want? tone section. Is it in there? Oh, that is the tone section.
Tell me why this isn't working. Looks like it's picking me up. Like it can be.
Way to call in, like by phone.
Yeah, you can.
We should do that. You get a phone allowance.
Yeah, $35 a month.
That's not, that's such a joke.
I don't know if I really want to go through all this.
No, there's no water here. Come, let's put some. Put some water. No, you have to put it through your mouth. No, through your mouth. You have to drink it and then it's gonna go in here. You have to drink it and then it's gonna go there. It's here. See?
Are you cute or what?
Should I finish the chips?
Okay. And the chicken good? Mama, no, I'm in the middle of something tricky. I can't show you. Okay.
Let's put some water here. But you have to drink it and then
Should I put him here or in the room? Yeah,
she looks very tired.
yeah.
She's yawning while giving her lunch.
You want to go nappy? You want Ima to take you? Yeah?
So you have to
Okay.
put him out here.
Okay. Could you please bring the, like a sheet for the thing? Yeah. I'll put him down. You want Ima to take you? Okay. Are you full? You're not hungry anymore? You full? Yofi. You want Ima to clean up? And if you're tired, I can clean up. If you're tired. Are you tired? You want to go to sleep? Ima's gonna do it then. مش ينفعش اللي تبقى متوقع. I like this one. Yeah, that's what I use.
Oh, I thought it was something.
No.
Where are you?
I think I smell poop, but
Pretty wow. Yeah, it's just pretty wow.
All right. Good morning, and thanks so much for joining our webinar today on COPPA 101. I'm really thrilled to have a slate of experts on COPPA to present to us today. The framework for today's discussion is around the FTC and Department of Education EdTech workshop on December 1st to examine how the FTC's rule implementing COPPA applies to schools and intersects with FERPA, which is administered by the Department of Education. In advance of this workshop, the FTC and Department of Ed are asking for comments to be filed by Friday, November 17th, in order to frame how they should be thinking about COPPA in schools. Perhaps the most important issue that will likely be raised at the workshop is how parental consent works. Are schools merely facilitators of an ed tech company getting parental consent for use of each and every ed tech device in schools? Or are schools able to consent on behalf of parents when a ed tech product is specifically and only used for an educational purpose? With that framework in mind, as I've previously mentioned, you can enter any questions you have now about COPPA or questions during the presentation in the Google Doc that is linked to in the chat box or in the email you received this morning. Today, our first presenter will be Linnette Attai of PlayWell LLC. With that, I'm going to unmute Linnette, and she will talk about the basics of COPPA.
Great, thank you, Amelia. Glad to be here today. Thanks everyone for joining. So I want to dive in and talk to you about the fundamentals of COPPA. What are the basics? This is a little bit of information about me for those of you I have not met yet. Just by way of brief background, I'm a compliance consultant, and I work with companies, schools, and districts to help them navigate their compliance responsibilities around a variety of laws, COPPA, FERPA, PPRA, state laws, GDPR, and more. But enough about me, let's talk about COPPA. What is it? COPPA is a law enforced by the Federal Trade Commission as well as enforced by state attorneys general. And its intentions are to ensure that parents control what data is collected from their child, and child here is defined as an individual under the age of 13. It's intended to ensure that we minimize the data that we collect from those children, that we only collect the data that we need in order to provide a feature or service, that we be transparent around our data practices, and that we implement reasonable security procedures. So what are the compliance requirements of COPPA? There are several. First and foremost is that you're obtaining verifiable parental consent before collecting, using, or disclosing a child's personal information. This is information you're collecting from a child, not information about a child that you may collect from an adult. You must allow parents to review the child's data, allow them to request that it be deleted, or request that you not collect any further information from the child. You must collect only the data needed to fulfill a feature or service. You can't condition a child's participation in a feature or service with collection of data that's not required for you to deliver. As I mentioned, you must implement reasonable security standards for you, reasonable dependent on the sensitivity of data you have on hand, and reasonable relative to industry standards and available technology. You must also ensure that any third parties operating with you can implement also reasonable security standards. You must post a prominently displayed accurate privacy policy, and COPPA has some specific requirements for disclosures that need to be in that privacy policy. And you must delete the data when it's no longer needed. So who needs to comply with COPPA? Assuming you all do, since you're here, but just for the sake of making it hopefully abundantly clear, COPPA applies to operators of commercial websites or online services, including apps and basically any internet-connected technologies. that are directed to children or that have actual knowledge that they're collecting personal information from children under the age of 13. Now, how do we define actual knowledge? How do we get actual knowledge? Oftentimes we know based on the type of site or service that we are operating, or we are asking users for their age, and so they're telling us they're under the age of 13, or we're told by some other means, perhaps a co-operator or a partner tells us that we're operating on a child-directed site. So not terribly complex, the ways that we gain actual knowledge, but really important to pay attention because once you do have actual knowledge, you're required to comply with COPPA. Co-operators of your site or service are equally responsible and liable. If you're operating a general audience site or service and you have a section there that is intended for children, then that section must operate in compliance with COPPA. So this is one of the areas where there are a lot of pitfalls with general audience sites and services when we don't pay attention to the header and footer that persist across the site or service which may include features that are not operated in compliance with COPPA, and we allow those to persist in the child-directed sites and services. Now, sometimes you will have a site or service that is directed to children, but children are not the primary audience. Right? And when your primary purpose is directing a site or service to children, you must treat all users as if they are under 13. Presume that everyone visiting your site is under the age of 13. Now, if your site or service is directed to children, but children are not the primary audience, you are allowed to age screen on those sites. You are allowed to ask children how old they are and treat them differently depending on whether or not they are under 13 or 13 and older. You may not block users under 13 from using your site or service. However, you can treat them differently in that you have to ask the under 13s, you have to obtain their verifiable parental consent prior to collecting personal information from them. So how do we ask children how old they are? We need to use a neutral age screening mechanism. Usually this is a series of drop-down menus that include the month, date, and year of birth, or a date entry field, an age date. Avoid tipping kids off to what the correct age is. Avoid tipping them off to the fact that those who are 13 and older will get in without going through a parental consent mechanism. That's not allowed under COPPA. In addition, a best practice is to, once you have collected the date of birth, to drop a session cookie. Prevents kids from easily changing the date of birth that they entered or the age that they entered in the event that they don't like the fact that you're not going to let them write in. Include a just-in-time privacy notification at the age gate as well. Make sure it's clear why you're collecting the date of birth. This is another area where it often goes wrong, particularly on sites and services that are intended for preschoolers, where oftentimes the company tries to get a little creative with the age gate. And instead of using a date of birth, asks for, I've seen everything from a simple reading question to a simple math question that may be tied thematically to the app. The challenge there is making the age gate complex enough that we know children will not be able to get the right answer. And the pitfall there that I often see are age gates that are created based on the subject matter being taught in the actual app, right? So we're actually teaching kids what they need to know to get through the age gate. So be very careful there on preschool properties. So do you need to comply? How do you decide whether you need to comply? Another significant area of pitfall where the site or service would pass the test for being directed to children, but often things are missed in making that determination. So you need to assess your target audience. You need to assess your product. You're looking for the attributes, the look and feel of the product. Is it based on a children's property? Is it educational in the say K-10 space? Is it gaming? These are triggers. Consider the whole look and feel of the product, not just the intent. The FTC looks at what we call the totality of circumstances test. And the basic parameters, what they look at, are listed out here. No one of these overrides another, and your intended audience is, at the end of the day, in practice, not all that compelling unless you have audience composition data that demonstrates that your audience is under the age of 13. So if your intended audience is 16-year-olds, but it looks and feels like a site or service that is intended for children, COPPA will apply. So what information is protected under COPPA? It's all listed here. This is what is considered personal information under COPPA. It's information that can be used to identify or contact a child. Keep in mind that definitions of personal information in other laws and terminology used to describe personal information in other laws varies, including definitions in FERPA, state student data privacy laws, and GDPR. So many of which sweep a much broader brush around personal information than COPPA. Some things to pay particular attention to with COPPA are the last bullet point, other data collected about a child or a child's parent when combined with any of the above. So if you're collecting non-personal information about a child or a child's parent, but you're combining it with the child's personal information that you've collected from the child, that non-personal information essentially becomes personal information. You need to treat it as if it was personal information, and so you need to have obtained the parent's verifiable consent before having collected it. So how you store and combine data is very important under COPPA. There are always a lot of questions about persistent identifiers and when they are and are not considered to be personal information. So first of all, persistent identifiers can be anything from an IP address, a UDID, customer number held in a cookie, a unique device identifier. It is considered personal information when used to recognize a user over time and across different sites and services. It may not be used to profile a user to serve behaviorally targeted advertising. It's not considered to be personal information when used to support specific internal operations. Those operations are to maintain or analyze the functioning of your site or app, so your basic analytics, to authenticate users or personalize site content, to serve contextual advertising or cap the frequency of ads, to protect the security, integrity of the user, the site, or the service, to ensure legal or regulatory compliance, and for network communications. There are no other permissible uses for persistent identifiers to be for internal operations. This list is all inclusive. Other uses considered to be personal information. So you need to consider, when you're looking at your data collection and your obligations under COPPA, you need to consider all data collection. There's the active data collection where you're requesting information directly from the user, for example, to sign up for a newsletter or create an account or enter a contest or send in some user-generated content. And then there's the passive data collection. This is invisible to the user. It's the data that's collected by your analytics companies, ad networks, social media plugins, video players, SDKs, other widgets and plugins. Persistent identifiers are often collected passively and transferred to third parties, and it is your responsibility as the operator to manage that collection and manage the compliance of that collection. Unless your third parties have actual knowledge that they are operating on a site or service that is directed to kids, the liability is strictly and wholly yours as the operator. So it's critically important when building your product to assess your potential third parties prior to engagement. Is their service free to you? If so, what is their business model? You may know that they are giving you that they are giving you analytics information, that you're giving them a persistent identifier, and in return, they're giving you basic analytics information about how your site or service is used. It's important to understand what else might they be doing with that persistent identifier that's not for you, but that serves some other business purpose for them. Because that's primarily where things go awry in relation to your alignment with COPPA, is that your third parties are doing something with your data and that essentially that is essentially that you disclosing the data for purposes that are not internal operations, for which you needed consent. So you need to, when working with third parties, do some due diligence, engage in contract terms that strictly limit what they can and can't do with the data, ensure that they actually can comply with those terms, make sure you're very clear on what data you're providing to your service providers, and consider a technical analysis, consider a deep proxy analysis to uncover what is happening with the third parties, what data is being transmitted, in what form, whether or not it's encrypted, and where it might be going. So once you have all that sorted and your product is ready to go, you need to provide notice and verifiable parental consent. Now, as I've said, you need to obtain consent before you collect personal information from the child. Now, in certain circumstances, a school may provide consent in place of the parents, and we have Sara Kloek here from SIIA who's going to do a deep dive into that area. So what needs to be in your notice? Notice must be sent to the parent advising what information has been collected in order to send them the notice and what you may want to collect from the child. How you're going to use the information. You need to include a link to the privacy policy, and you need to explain to the parent how they can provide consent if they want to. Now, a note about your privacy policy. Your privacy policy must accurately and thoroughly reflect your data collection and handling practices. It's not uncommon to take inspiration from someone else's privacy policy, to borrow a phrase or so, but make sure you understand your privacy policy that's accurately reflecting your practices. A link to the privacy policy must be posted prominently on the home page of your product and in any area in which you collect data. Now, usually, to avoid sprinkling the privacy policy in close proximity to areas in our product where we collect personal information, we usually post the privacy policy in the footer and have that persist across the product. It's okay to do that. However, when you do, the link to the privacy policy must be prominent, usually in bigger type and a different color than other links in your footer. It can't be in the same mouse type as everything else. It has to be prominently displayed. So consider different font sizes and different colors. And consider then just-in-time notifications when data is collected. So how do we obtain this elusive parental consent? There are a variety of methods that have been approved by the FTC for ensuring that the person providing the consent is the parent. You can propose other methods. They must be reasonably calculated in light of the available technology to ensure that the person providing consent is the child's parent. But the approved methods include a signed consent form that a parent may mail, fax, or scan into you. A credit card or online payment. This is one of the most common ways in which we get parental consent, by charging a credit card. You could, if you choose, man a toll-free phone number with people staffed who have been trained to recognize a parent. You can, if you choose, do video conferences with parents. You may check against a government-issued ID, such as a driver's license or social security card. Of course, you're going to want to delete that information as soon as you have checked and verified the identity of an individual. You can engage in what is known as knowledge-based authentication. This is the authentication most commonly used by financial institutions. It consists of asking a series of questions for which really only you would know the answer, such as what address did you live at 3 years ago, or what was the make and model of your first car. But often the most common method for providing notice and obtaining parental consent is charging a credit card. Or if you're going to use the data only for internal purposes, you may use Email Plus. Email Plus essentially consists of sending an email to the parent with all the notice requirements in that email, requesting their consent, allowing them to provide the consent online, and then following up a short time later with a subsequent email just confirming their consent. That method can only be used if you're not going to disclose the data publicly. So there are, of course, with every good law, there are exceptions to the rules. So if you are using the data just to respond to a one-time request from a child, you do not need to obtain parental consent. This is most common in situations where you have a contact us form. And a child may write something in. You are allowed to respond once to the child, but you must delete the data as soon as you've responded. It's also very common in e-card features, send to a friend requests. Just be sure the data is deleted after you've responded once, and that must be a hard delete, not stored in your servers. Multiple contact exception, when a child requests multiple contact, for example, they've signed up for a newsletter. You may send them one newsletter. You must notify the parent that the child has signed up for this newsletter, for this multiple contact. Give the parent the ability to opt their child out of multiple contacts. If the parent opts the child out, the data must be deleted. If not, you may continue sending that newsletter to the child. In addition, if you're posting information to public forums, for example, if you have asked for user-generated content, you post it to public forums, but you delete personal information before posting, that data is not deemed to have been collected. Remember that parents always have the right to request to review data or categories of data that have been collected from their child, request that data be deleted, request that no further contact be made with their child, and approve the collection but not disclosure of the information. Also remember that you need to implement the physical, technical, and administrative safeguards to protect the data and maintain it only as long as is reasonably necessary. So again, with data minimization, only collect the data that you need, and once you've fulfilled a feature or service, make sure you delete the data. Now, in talking about parent rights, I think this is a good segue to transition over to Sara, who I believe is going to talk to us a bit about COPPA in schools.
That's right. Next up, we have Sara Kloek at the Software and Information Industry Association. Sara, you can go ahead and share your screen.
Great. Let me bring this up, make sure I'm doing
As
this
a
right.
reminder, as Sara is doing that, if you have questions now or during the presentation, please post them in the Google Doc in the chat link or in the link that was sent out also to the Google Doc in the email this morning. Sara, currently we are seeing presenter view of your slides.
Oh, well, let me fix that. Let me unshare my screen and start this over. Oh no.
That sounds ominous.
It's not ominous, it's just I have multiple screens up, so let me try this again.
One other announcement, if anyone did not register for this webinar and got access through someone else, if you can please be sure to email me. My email address is in the Google Doc to make sure that you get the notes and slides after the meeting. With that, we have Sara's slides, and I will let her go ahead and talk about COPPA in schools.
Excellent. Amelia, is it the right slide?
Yep.
Awesome. I am technologically advanced. Hi, everyone. My name is Sara Kloek, and I am with SIIA. I'm the Director of Education Policy here. We are based, SIIA, I think most people are familiar with us, but we are a trade association based in Washington, D.C., and we work, we are one of the largest, or probably the largest technology trade association. So I'm happy to be here today to talk about my favorite topic of COPPA in the schools. I would like to say that it is abundantly clear and very straightforward, but it is not. It is something that is complicated, and that's why I'm so happy that the Department of Ed and the FTC are holding this workshop to talk through some of the issues on how best to protect student privacy and give schools the flexibility, schools and students the flexibility to use the really cool, awesome new technology that is out there. So with that, Just a brief overview of what I'm going to talk about. COPPA's introduction in the Senate. I was just looking at that yesterday and have something interesting to share there. I'll go over COPPA's regulations, guidance, and best practices related to schools, and then I'll briefly touch on other federal laws that impact schools and how they align with COPPA. So I was digging in yesterday, looking at the congressional history of COPPA, and saw the introductory remarks from Senator Richard Bryan from Nevada. That is very, the whole speech is interesting, but I really liked this quote from him. I think all would agree that proficiency with the internet is a critical and vital skill that will be necessary for academic achievement in the next century. The benefits of the internet are extraordinary. So just as we're thinking about this, keep that in mind. The original senator that originally introduced this and eventually passed it into law through a transportation appropriations bill, really did see the impact that the internet could have for the future of our country. So after COPPA was passed, again in that transportation appropriations bill, the FTC began the rulemaking process, and in 1999 they came out with the final rule that is many pages long and has has 2 paragraphs on schools. I wanted to draw your attention to the bolded sections that explain the FTC was thinking about COPPA in the schools in 1999. And again, this is way before any of the technology we are using today was even thought of. So first, the rule does not preclude schools from acting as intermediaries between operators and parents in the notice and consent process, or from serving as a parent's agent. And then later, the bolded section, the operator can presume that the school's authorization is based on the schools having obtained the parent's consent. These are sort of 2 different statements on the process of how consent might be obtained by an operator that needs to collect information from children for a school purpose. Again, I'm just talking about schools here. I'm not talking about the larger consent process. So I'm approaching this as under the context of a school wanting to use educational technology in the classroom. Here's another interesting tidbit from COPPA's 1999 final rule. The Commission intends to provide guidance to the educational community regarding the rules' privacy protections. So here is what we have on the guidance from the FTC. Section M of the COPPA FAQ has five frequently asked questions that go into how a school may provide consent. And again, it is not, like I said at the top of this, it's not very clear how that process should happen. So COPPA FAQ M1 says that the schools may act as the parent's agent and can consent to the collection of kids' information on the parent's behalf. And then number 2, just the next paragraph is that the operator can presume that the school's authorization for collection of students' personal information is based upon having the school having obtained the parent's consent. That's 2 different processes, and it's pretty unclear. And there's also a point to be made that actually, I'm just going to go to the next slide to finish this thought. But so M3, M4, and M5 just talk about best practices on who at the school may provide consent. They suggest that the school or school district instead of the teacher. And again, these are best practices and not requirements based on COPPA. They say that the school should consider that providing the parents a notice of the technology for which it has consented. And then the M5 outlines what sort of information a school should seek out before providing consent. So based on all of that, we don't know, there's not a very clear process on that you could write out in checkboxes on what you need to do when and how it works in the schools, which again, we're grateful for the FTC and Ed for holding this workshop to go through how COPPA actually works in the schools, whether a parent or a school can provide consent, and then all of the other associated rights that COPPA guarantees. Where do those rights go? So just briefly on the other laws that are that you see in the school. FERPA is the one that most people are familiar with. On the left of the screen are the requirements. Oh, there's a typo with number 4 there. The requirements that for the school official exception under FERPA, in which a school would be able to share information from a student's education record with somebody the school deems as a school official. It's very limited, and the information that is shared by the school can only be used for authorized purposes. And I actually read this in I think this reads well alongside COPPA's school consent allowance, which is outlined in the COPPA FAQs, that they say a school's ability to consent for the parent is limited to the educational context, and the information is only used for the use and benefit of the school and for no other commercial purpose. I read those as pretty harmoniously and see how they are aligned. I do want to briefly touch on PPRA, the Protection of People Rights Amendment, which is a fairly obscure law that governs the administration to students of a survey in certain protected areas. And it also concerns marketing surveys. It does not apply to the use of personal information collected from students for developing, evaluating, or providing educational products or services for or to students in educational institutions. So there's a little bit of a caveat there, but it's important to remember that PPRA exists and is something to consider when we're talking about COPPA and FERPA. And with that, I will hand it over to Emily.
Fantastic. Thank you so much, Sarah. We now have Emily Tabatabai from Orrick to present on enforcement and compliance of COPPA. Again, reminding all of you that if you have questions now or during the presentation, you can post them anonymously in the Google Doc. We already have some of our speakers answering questions in the Google Doc. So please enter them there. And now I will let Emily present on enforcement and compliance. Emily, are you there?
I am. Can you hear me?
There we go. Yep, we can hear you.
Okay, that worried me for a second. Thanks, Amelia.
Okay, here to talk about COPPA enforcement. So what does this all mean for your bottom line? The FTC is the primary enforcement authority, although states' attorneys general have taken COPPA cases before. The FTC has the ability to assess monetary penalties of up to $40,000 per violation. That means per child whose information was collected not in compliance with COPPA. That penalty amount went up from $16,000 about a year ago. $16,000 was already pretty incredible when you consider the numbers that websites often have participating on their site. The penalty amount jumped to $40,000 last year, and the FTC hasn't yet brought a consent decree in a COPPA matter involving this higher penalty amount. But we can expect to see some pretty high numbers. They aggressively enforce the statute in part because everyone can get on board with the need to protect children's privacy. There's been about 30 public consent decrees and an untold number of non-public investigations. The penalties in these consent decrees have ranged from $35,000 to $4 million. Oftentimes, though, the FTC will assess this massive penalty and then will suspend some or most of the penalty because of the company's inability to pay. When that happens, though, the company is still going to be subject to the non-monetary components of the consent decree. And if they violate any of those, then typically the entire monetary amount comes due. So I mentioned the non-monetary components. In addition to civil penalties, the FTC always imposes some other non-monetary but yet burdensome duties and obligations. And oftentimes these can last for up to 20 years. So that can include mandatory data destruction, deleting everything that you have inadvertently collected or incorrectly collected, 20-year auditing and reporting requirements, consumer education requirements, where you actually have to post like news about COPPA and instructing consumers on how they can protect themselves, and all sorts of things that when you consider the life of a tech company, a 10-year or a 20-year obligation can be significant. Okay, how do you become the target of an FTC investigation? There's many different ways, but some of the typical ones are if you experience a data breach. Sometimes if there's a data breach, the FTC and from time to time the state's attorneys general will send an inquiry asking questions about your security practices, the nature of the breach, and then they may slip in a question that says, how many of your users are under 13? I cannot tell you how many companies believe the answer is 0, and then they research it a little bit to answer this question and realize that, oops, they inadvertently do have a ton of people who have reported a birth date as being under 13. The FTC also engages in industry sweeps and targeted enforcement. So sometimes they'll decide to focus on a particular industry or a particular portion of the industry. I think we all remember recently, they were very interested in mobile apps for children. So we had a couple of different reports that were coming out, like mobile apps are disappointing and things like that. Targeted enforcement is when the FTC wants to make a particular point and bring consent decrees, or at least investigate companies over matters that they're particularly interested in or that have raised particular privacy concerns and they want to address. And then consumers and frankly competitors can also file complaints about a company's COPPA practices. The FTC and the state will also receive complaints from the state's attorneys general, the Better Business Bureau, consumers, and sometimes those complaints, particularly if there's more than just one or two, can lead to an investigation. Okay, I want to highlight a couple of different common enforcement themes so we understand how these are applied against standard business practices. So a couple cases here involve companies that were directed to children. Their services were directed to children. That makes sense given that COPPA is a regulation that is designed to protect children. The typical cases are like these last two down here below, Tiny Company and Skitty Kids or Skitty Kids, I don't know how they pronounced it. But these were online gaming websites or apps that were clearly directed at children, things like Tiny Pets and the Facebook and MySpace for kids, which really didn't have any hope of going well, I don't think. These are just child-directed sites that didn't have any sort of COPPA compliant mechanisms in place. They didn't ask for a parent's email address. They didn't even attempt to get parental consent or to send a notice. The less typical cases are these two newer ones. In December of 2015, the FTC brought consent decrees, settled consent decrees, against two mobile app developers, LEI Systems and Retro Dreamer. Both had very, very similar facts. They were the makers of child-directed apps, clearly child-directed apps like My Cake Shop, My Pizza Shop, Happy Pudding Jump, and similar. Neither one of them asked for personal information from children. They didn't ask for a name or an email address, but they both allowed third parties to collect information on their sites for advertising purposes. And because those are persistent identifiers, that was an improper collection of information from children under 13 without consent. Okay, on the flip side, there's also a bunch of COPPA consent decrees brought against companies that are not directed to children. Yelp is a great one that we've probably all heard of recently. It's the typical case that it was directed to adults or to a mixed or a general audience site, but they asked for a birth date, and therefore they have actual knowledge that children on their site are under 13. I'm going to speed through a little bit just to make sure we get to the end. Okay, insufficient COPPA notice and consent cases. These are cases where the company implemented an age screen, but still failed to meet the COPPA compliant obligations. So a couple of examples. Playdom would send parents a welcome email, but it didn't include the COPPA required disclosures. Xanga was a social network, and Xanga had an age screen, but the age screen said, quote, you hereby certify to Xanga that you are at least 13 years old. Xanga is intended for people who are at least 13 years old. And then just to hit the point home, children under 13 are not permitted to join Xanga or to participate in the Xanga community. And then you clicked, I confirm, and then you could continue entering your information, including your birth date, which allowed them to enter a birth date that was under 13. So that's a perfect example of a non-neutral age screen that invited falsification. I really want to spend a couple of moments talking about these cases that were brought by the New York Attorney General. So as we've all mentioned, the COPPA is primarily enforced by the Federal Trade Commission, but it can be enforced by the state's attorneys general as well. Texas, New Jersey, and New York have all brought COPPA cases. Last year, in September of 2016, the New York Attorney General brought 4 cases simultaneously as part of their Operation Child Tracker. They brought them against major media companies, Viacom, Mattel, Jumpstart, and Hasbro. These companies had child-directed and general audience sites like Nick Jr. and Nickelodeon, Barbie, Hot Wheels, American Girl, My Little Pony, The Littlest Pet Shop, and Nerf. This is the largest state action to date. The penalties in total were about $850,000 against the 4 companies. But what's more interesting to me is that these cases push further than the FTC's previous enforcement actions relating to the online tracking of children. So the the New York Attorney General highlighted a couple of different things. One, they highlighted the fact that tracking was done by third parties operating on these child-directed sites. So they noticed, for example, that a lot of trackers on Nickelodeon sites were also implemented by other third-party tracking technologies, which then tracked, profiled, and targeted advertising to kids. There's no indication that Viacom intended for advertising tracking to occur on their child-directed sites, but they were unaware that their parties that they had engaged with were then bringing in other third parties to track. Similarly, Mattel used another third-party analytics provider, which was also bringing in third parties to track. It's called piggybacking, when one type of cookie piggybacks on the other. Mattel and Hasbro both also had social plugins, or not social plugins, types of plugins. So like imagine a YouTube video embedded on their site. And those plugins from third-party sites included tracking cookies, which were then collecting information about viewers on Mattel and Hasbro sites. So one, COPPA is definitely a strict liability statute, but these examples were all interesting and that the companies truly had no idea that third parties were engaging in this type of behavior on their own sites. The second part I thought was extremely interesting is the New York Attorney General focused on the mixed use nature of the Nick Jr. site. They said that the site was a mixed-use site and therefore needed a COPPA-compliant age screen. Viacom argued that Nick Jr. shows appealed only to kids who were like age 2 through 5. And 2-year-olds, they argued, were not going to be browsing the web. These sites were clearly directed at their parents. But the AG disagreed, noting that the child-directed contents of the site, the cartoon characters, all of these things would appeal to children under 13. And therefore, at least in part, the site was directed to those children. It should be considered a mixed-use site. Now, the mixed-use site is required to believe that every user on its site could be under 13 and to act accordingly, for example, by installing an age screen to differentiate between the under 13 users and the over 13 users. But what was fascinating here, to me at least, was that Nick Jr. and Viacom had a somewhat reasonable, well, in my opinion, a reasonable argument that the site that was perhaps housing content that could be appealable to children was not directing their services to children who are likely too young to actually use this site. And I think that this really could be interesting for our educational technology companies, oftentimes whose websites are directed to schools and parents and other purchasers or coaches or teachers who are providing services to students, but the content on their site is interesting to students and therefore is likely collecting or attracting students or student age users. So this concept of mixed use and the higher standard that companies have to follow when a site could be at least directed in part to children under 13 is very notable here, I think. The AG also in these New York cases highlighted a couple of different coding errors. So, miscoding, trackers inadvertently placed across all different properties instead of only on certain pages. These were inadvertent errors, but again, this underscores the strict liability sort of nature of the statute. So in addition to the monetary penalties that the New York AG brought against these 4 companies, actually I should say 3 companies, if you look down at the bottom of the slide, I note that Viacom, Mattel, and Jumpstart all paid hundreds of thousands of dollars in penalties, but Hasbro paid 0. That's because Hasbro was participated in a FTC-approved COPPA Safe Harbor program. And so even though it was still found to be in violation of the statute, it was not assessed monetary penalties for that violation because it had participated in the Safe Harbor. But in addition to the monetary penalties, the New York settlements required a couple of different comprehensive reforms, which I find could be potentially helpful for companies trying to figure out how to proactively address some of these risks. So first, they required the companies to do a regular scans of their properties to monitor for unexpected third-party tracking technologies. Annoyingly, I think for the companies, they also have to then report these scans to the Attorney General's office. But the scans themselves are certainly a good idea as a best practice. Second, they have to adopt specific procedures for vetting third parties before they're allowed to introduce those parties on their child-directed websites. And those vetting procedures also include determining whether and how these third parties would permit other third parties to be present on the site. And then they also had a couple of different requirements about updating your privacy policies and providing better notices and whatnot. So the lessons learned from all of these consent decrees: 1, don't ask for a birth date without an age screen. Over and over and over again, companies make that mistake, thinking that of course their sites are directed only to adults, but the day that you ask for a birth date is the day that you have actual knowledge if somebody doesn't enter the correct one. In the Yelp case, for example, they argued that less than 0.2% of their audience was under the age of 13, and that many of them were probably incorrect because they were listed as like being a day old or being less than a year old. The person simply did the drop-down button and picked like 2016 as the date. So obviously they're not going to be less than a year old. These numbers were incorrect, but nonetheless, they still had a birth date and they were collecting information, and that gave them actual knowledge of the data collection. 2, if you do consent, if you do try to get consent, do it correctly. 3, take affirmative steps to monitor and oversee the third parties who are operating on your site. Can you scan for rogue trackers that you don't have, you didn't plan or intend to have on your site? Can you contractually limit with your third-party partners, contractually limit piggybacking? All of these things are extremely challenging to do given the complexity of the ad ecosystem. So, at a minimum, routine scans for rogue trackers are important, and maybe one of the best ways you have to prevent or to at least recognize and prevent unwanted tracking. 4, carefully consider your audience. Is your site directed, at least in part, or at a minimum, some degree, directed to children? Is it directed to an adjacent age group? So is it directed to, the 13 to 16-year-old range? If so, it's likely also attracting children who are below that age range. Are there certain pages on your website or your service that are potentially directed in part to children? Carefully consider whether you could be deemed a mixed-use site. Be particularly careful of login pages. So even if the site or even if the web page itself is not really directed to a child audience, what happens if there's a login page on that screen? And what happens if children routinely go to that screen to then log into a service? No case has been brought involving that scenario, but if I were clairvoyant, I would think that that would probably be a risk that I wouldn't be willing to take. 5, employee training. Does your digital marketing team understand COPPA? Oftentimes, they don't fully understand the implications of partnering with a new ad partner, understanding how the ad partner's technology works, whether or not that partner will then bring down other sorts of ad tracking technologies, either their own or another third-party companies. And finally, check. Mistakes can be very costly, and you don't get any bonus points for unintentional mistake. Make sure that you continuously check for COPPA compliance if your site is directed to children, or at least in part, or if you have any actual knowledge that children may be using your site or service. And on that note, I don't have my clock in front of me, but I think we're about done. Amelia, did you want to follow up?
Absolutely. So we have about 5 minutes left for questions. So let's see, I'm gonna make sure all our presenters are unmuted so you can answer questions. As many of you will see in the Google Doc, we have a lot of questions already answered, so I'm gonna focus on those that haven't had a typed answer so far. So first of all, for Linnette, could Linnette explain more about what it means to remove personal information from user-generated content before posting when she was talking about exceptions? Or perhaps give an example.
Sure, I'd be happy to. So one example of this would be if you are asking children to send in photos, and perhaps the photos are of flowers, let's say. That's what you ask children to take pictures of. But they all took pictures with their smartphones, and they had location services turned on, as we often do when they took pictures. And so what you got were great pictures of flowers, but you also got geolocation data embedded in the photo. So your responsibility would be to remove and discard that geolocation data before posting the photo. And if you do that, you're not deemed to have collected personal information. In other words, you don't have to have gone to the parents and asked for their consent to collect the geolocation data if you're going to discard it before you post it. This is also very common in chat features, and I'm answering a question in the Google Docs about chat features, where recommended practice, if you're allowing children to chat online, you may have profanity filters and other safety mechanisms in place, but also you want to discard their personal information, any names, numbers, addresses that they may disclose before you post what they have to say. If you do that, again, you're not deemed to have collected the personal information. You don't have to have gotten prior parental consent before collecting it from the kids.
Great, thank you, Linnette. Moving on to another question, the FTC recommends the following. If an operator intends to use or disclose children's personal information for its own commercial purposes, in addition to the provision of services to the school, it will need to obtain parental consent. They cannot use personal information collected from children based on a school's consent for another commercial purpose, because the scope of the school's authority to act on behalf of parents is limited to the school context. How can a vendor navigate getting that consent? How do they know when a school provides consent but can only give limited consent for an educational purpose? So maybe for this one, let's start with Emily.
Hi, so unfortunately I missed the very beginning of the question, but the end of the question was, how do we know what the extent of the school's consent and what does it extend to? The school can only provide consent for educational purposes under COPPA. So we automatically know if we're relying on the school to provide that consent, it cannot be for non-educational purposes. You can't, for example, write into the contract that as part of the services you provide to the school will include targeted advertising, because that is a use that the school simply can't consent to.
Thanks, Emily. Linnette or Sara, do you have anything to add?
This is Linnette. I would just add also to, although the operator under COPPA may obtain consent for use of the data for other commercial purposes, just remember also for the operators listening that the state student data privacy laws have very significant restrictions on student data for when used in commercial settings or using student data for commercial purposes. So be mindful that it's not just COPPA that applies. Across all of these discussions, actually, it's not just COPPA that applies, but there are other laws that you need to consider that don't allow parental consent to override.
Linnette brought up a great point. I also want to add one last thing, which is when you're relying on a school for consent under COPPA and under these state student data privacy laws Linnette mentioned, the consent for certain purposes should always be addressed in the contract. What does the contract say that the purposes of the collection are? What type of uses are permitted? What services are you providing? And what other uses may you make of that data? All of that should be addressed. And to the extent that it's not, or if the contract doesn't permit a certain type of behavior or use case, then you don't have consent for that particular activity.
Thank you. And then one last question for today. How does COPPA apply to web extensions, such as with Google extensions and app plugins? For example, parents have consented to G Suite for Education, or the district has worked with Google to designate them as a school official under FERPA. However, third-party extensions are available that change the feature set of these apps and also can collect PII. Typically, we don't block these as we could for other websites under the, trying to remember what SIIA stands for, but under SIIA, because doing so would also block Google, which is already approved. So anyone want to answer that question or venture a guess?
This is Sara. I think extensions are just the same. You can think of those the same as apps. If they're collecting personal information from children, they have to get consent.
Hey, it's Emily. Hey, Sara. I totally agree with you. I was also just going to add, because I couldn't tell from the question itself, which party is actually adding these extensions. So if the website operator is the one responsible for the extension being added, then they are also responsible as a third party who's operating on their site. If instead the extensions are added by the school, by a parent, by another user, they just happen to be placed on the browser when the browser happens to be pointed at your website, then you may not be the one who's responsible for that third-party collection, because you're not the one who added and gave it permission to collect information from any site that browser goes to. So the answer to that question may depend on how that extension was accessed, what type of data it's collecting, but primarily how it's accessed as to what or how it's not just accessed, but provided as to what your responsibilities would be for it.
Wonderful. Well, that, I'm afraid, is the last word since we are out of time. Thank you so much to our presenters. If anyone on the webinar has questions about FTC comments, please feel free to reach out to me or anyone else at FPF this week, and we'll be happy to let you know what are open COPPA questions versus things that do have answers. And remember that comments can reflect not only what you think the state of things should be with COPPA in schools, but also the questions you want the FTC and Department of Education to answer for you, whether you are a school or a vendor. I also want to let all of you know that FPS has a guide to advertising technology and education based off of our series of webinars on that earlier this year, and that will be coming out within the next few weeks. So that may also help answer some of your questions, or at least clarify what we do not know. With that, thank you all again for joining us today. The slides from today's webinar are linked to in the Google Doc, and we will send out notes and a recording of this webinar probably early next week. Thank you all again for joining us, and have a great weekend.